Morning, Miss Sherly and Miss Vira. Today we as a contract team from our company, PT Innovatif Jaya, will have a meeting with the supplier PT Maju Steel Maneuver.
Okay, morning, Miss Jessica and Miss Vira.
Yes, morning, Miss Jessica and Miss Sherly. Sure, I think we have enough preparation and set this meeting so external people can join this Zoom. I will send an invitation link to the supplier so they can join now. Should we invite them now?
Okay, I will invite them now. Hello, greeting to you and your team, Miss Octaviany, as representative from PT Maju Steel Maneuver. Unfortunately, we have to set up this virtual meeting due to this COVID-19 pandemic. So, hope you're doing fine there.
Well, hello, Miss Sherly, Miss Jessica, and Miss Vira. I hope you're doing well too. Maybe we can start with a member introduction first because I'm afraid you might forget about my team. Yes, please, Jennifer.
Yeah, allow me to introduce myself first. I am Jennifer from PT Maju Steel Maneuver from Contract Management Department, working in a place same team with Miss Octa, Miss Kerin, Miss Trisa. Nice to meet you all again.
Hello all, I am Kerin. As a witness person in my team, nice to meet you all again.
Morning, I'm Trisa Monica from a Contract Management Department too. Nice to meet you all again.
Thanks for the greeting and introduction. Such a pleasure to see you and your teams again, Miss Ota.
It's also nice to meet you and your team again, Miss Octa. In like to Miss Carrie introduction, I'm also stand for a witness position in my team.
Thanks for your warm greeting, all. Should we start the discussion about renewal contract agreement for heavy equipment now? I bet some of you have received the soft copy of contract, and we will proceed to sign up the contract by today if both parties are agreed.
Okay, we have it on our hand, so we can start it for the safe time, please.
Sure, we would like to do a share screen to review clauses by clauses on the contract. Please wait a moment.
Okay, first, this is the renewal contract agreement. So, if we both agree to continue this business relationship, so we start this agreement today, which is 10 June 2021. Validity still the same, which is 6 months. Nothing is different on this contract agreement, but before we process to sign off, better if we go through one by one clauses.
Yes, the first is general provisions, scope of applications. This agreement shall be then incorporated into its purchase order that we client issue to supply. The purchase order, the specific terms set out in the purchase order and our agreement shall constitute the contract agreement between the client and the supplier. For the service and where applicable for the supply, installation, testing, and or commissioning of the spare parts and more particularly described in the purchase order.
Okay, so as usual, we will issue a purchase order or as known as PO to confirm things like spare part and service that we buy. I think it's clear enough because we had ever done this contract for a years. If you have any concern related clause number 1, please let us know.
It's clear, Miss Sherly.
I think it's okay and we will continue to clause number 2. Purchase order and service description. No quotation submitted by the supplier shall be deemed to be a captive by the client unless and until confirmed by the issuance of the purchase order. with list and purchase order may make reference to the supplier quotation. The client does not recognize any terms and conditions imposed the supplier, whether through the supplier quotation or otherwise, unless the client has expressed agree in writing the application of such term and condition in the purchase order. The quantity, quality, description, and any specific of the service, include the spare part if applicable, shall be those set out in the purchase order. The purchase order may make reference to the description and or specification of the service, include the spare part if applicable, collective the service description as set out in the supplier quotation. The supplier shall be responsible for ensuring the accuracy of the service description. No adaptation, variation, or amendment may be made to the service description without the client prior written consent. No contract agreement which has been accepted by the supplier may be cancelled by the supplier without the client prior written consent. The time for the performance and the delivery of the service, include for spare part if applicable, shall be of the essence.
Okay, I will read the number 4. Payment. The payment terms applicable to the price shall be as set out in the purchase order. The service shall be deemed completed when a certificate of acceptance of the service is duly signed by an authorized representative of the client.
Okay, I will continue to review clause number 5. Performance of the service. The supplier shall perform the required service and supply the spare part in accordance with the terms and conditions of the contract agreement, where a specific completion date and/or delivery date is stated in the purchase order. The supplier shall ensure that the services are complete no later than the specified completion date and/or the spare part are delivered in accordance with the delivery time, no later than the specified delivery date. In addition, where service level and performance guarantees are applicable to the service and/or spare part, as more particularly described in the relevant purchase order, the supplier shall ensure that such service level and performance guarantees are fulfilled and achieved in accordance with the terms of this contract agreement. Continue to point B. The supplier undertakes to perform the service with due diligence and efficiency and in conformity with sound industrial practice. C. Where the supply or replacement of a part of component and equipment is required under the contract agreement spare part, the supplier first shall plan, monitor, control, and manage the delivery of the spare part of the equipment and the progress of the service and coordinate the timing of the performance of the service so as to ensure that there is no unwarranted interruption and delay caused to the use and operation of the equipment by the client. Second, supplier shall comply with all applicable regulation or other legal requirement concerning the manufacture, packaging, packing, and delivery of the spare part in Indonesia. Third, supplier shall, where the supplier is the manufacturer of any part in the spare part, manufactured by the spare part according to the service description and shall not alter, modify, or vary the spare part without the prior written consent of the client. Fourth, where the supplier purchased any part of the spare part from third parties, ensure that all the spare parts so purchased shall conform to the service description. Fifth, pack the spare part in seaworthy packing or such manner as may be specified by the client from time to time. Or sixth, ensure the spare part of the equipment so supplied pursuant the contract agreement shall be able to integrate and use together with the existing equipment of the client. The supplier shall be solely responsible for the care and custody of the spare part until the certificate of acceptance has been duly signed by the client.
And the sixth was rigs and property, where spare parts are required to be supplied under the contract agreement. Rigs shall pass to the client where the services are complete as evidenced by the insurance of the unqualified certificate of acceptance by the client to the supplier. Title in the spare part shall pass to client upon delivery.
The next clause is 7 is warranty. The supplier warrants to the client that it shall perform the service in a proper, workmanlike, and professional manner and shall ensure at all times that its conduct will not cause annoyance or disruption to the client operation and business. It shall perform the service it provide in timely, diligent, and efficient manner. Third is it shall not and shall procure or cause its personal employee or representative that it used to provide the service shall not commit any misconduct or misbehave themselves, do any act or thing which would be contravention with the rules and regulation of the client and the law in Indonesia when perform any part of the service, and it professes the specific skill and experience relevant to the service. B is where spare parts are required to be supplied under the contract agreement. The supplier warrants that the spare parts so supplied will be free from defects in material and workmanship developing out of normal use for a period of 12 months with effect from a date of delivery warranty period. If there are any defects to the spare part during the warranty period, the supplier shall, at its own cost and expense, carry out all work to receive the defect, and if any of the spare parts are to be replaced, defective parts, the defective parts shall be replaced with new and original parts with conform to the service description and the terms of this contract agreement. Replacement parts. The supplier future warrants that the replacement parts will be free or defects of a period of 12 months from the date of its replacement with the defective part. The spare part will be correspond with the service description as described in the purchase order. Reasonable care and skill has been used in the design manufacture of the space part. The fourth is the space part will be new and satisfactory quality. Five is the space part will be fit for purpose. And six, the spare part will complete with all statutory requirements and regulation relating to this spare part in Indonesia. The supplier warrants that the performance of the service include but not limited to the supply, installation, testing, on commissioning of the spare part does not infringe the intellectual property right and third party. If any claim is made against the client that the service include the spare part, if applicable, infringe or that their use or performance infringe the intellectual property rights or any other person, the supplier shall indemnify the client in full against all liability, loss, damage, demands, costs, and expenses, whether direct or indirect, including legal expenses on indemnity basis awarded or incurred or paid by the client as a result of or in connection with such claim.
Okay, I will continue to number 8. Delay or failure in the completion of the service. A. Without limiting any other remedy, if the service are not performed and completed in accordance with the contract agreement, then the client shall be entitled at the client's sole options. The first, to require the supplier to re-perform the service or any part thereof ensure that the service are completed in accordance with the contract agreement with it within 14 days of the client's notifications without extra charge. Or the second, the complete on in its own and or appoint a third party to complete the service, the cost and expense of which are incurred by the clients. B. The suppliers shall indemnify the client in full against all liability, loss, damage, costs, and expenses awards are incurred or paid by the clients as a result of or in connections with. The first, a breach of any warranty given by the suppliers in relation to the service. The second, the occurrence of any defect of the spare part causing the spare part to be unfit for intended use or reducing its quality. The third, any acts or omissions of the suppliers or its employees against or subcontractor in performing the service and the supplying, delivering, installing, testing, and or commissioning of the spare part. And the last one is any breach by the suppliers of any of the provisions of the contract agreement.
Okay, I will continue review the number 9. Confidentially. The supplier acknowledges and agrees that confidential information as defined below will be or has been disclosed by the client to it. The supplier further agrees that the obligation of confidentiality shall continue in full force and effect after the expiry of or the termination of the contract agreement or until the information properly comes into the public domain without the breach of any or the provisions in these conditions. The term confidential information for the purpose of the contract agreement shall first mean any and all information disclosed, furnished, or communicated by or on behalf of the client to the supplier through the supplier's director, officer, employees, representatives, or agents in connection with this contract, agreement, or the service. And or the second is mean any and all information disclosed by the client to supplier, whether in writing or other tangible form, and clearly marked as a property or confidential at the time of disclosure, or which is not intangible from but is clearly identified by the clients as proprietary or confidential at the time of disclosure.
Okay, I will continue to read and review the clause number 10. Termination. The client may terminate the contract agreement immediately by giving notice in writing to the supplier in any of the following events. First, if the supplier shall at any time fail to perform and complete the service by the relevant completion date as stated in the purchase order. Second, if the supplier fails to deliver the spare part by the delivery date. Third, if the client is entitled to reject the service and or spare part. Fourth, if the service performed by the supplier is not in accordance with the service description of the purchase order and or in contract agreement. Fifth, if the supplier shall have a receiver or judicial manager or any person with similar power in the country of incorporation of the supplier, appointed over any parts of country its undertaking or assess. B. Shall pass a resolution for winding up otherwise than for the purpose of a bona fide scheme of solvent amalgamation or reconstruction, or any other analogous proceeding, or a court of competent jurisdiction shall make an order to wind up the supplier, or any other similar order is made. The C condition is shall cease and threaten to cease to carry on a business, or fourth, shall be wound up, or a winding up or judicial management petition is present, or any other analogous proceeding are commenced against the supplier. Fifth, If the supplier otherwise neglects or fails to perform or observe any of the provision of the contract agreement or commits any breach of its obligation in the contract agreement, which is not remedied to the satisfaction of the client within 30 days of a notice in writing to the client requesting its remedy. The last condition, if the supplier continue or discontinue its business operation for 30 days or more, or announce any plan of its intention to do so, and if such default continues uncured for a period of 10 days or more after written notice has been given to the supplier, then the contract agreement will terminate on the date of the client's written notice of termination.
Next, I will continue. Number 11 is notice. All communication in writing, including notice between the parties with respect to the contract agreement, shall be delivered by hand or sent by prepaid registered post with recorded delivery to address or fax number of the other party as set out in the purchase order, or to such other address or fax number as the address may from to time have notice to other party in writing. And the second is the contract agreement, the relationship between the parties, and the interpretation of the contract agreement shall be governed by interested and accordance with the law of Republic Indonesia.
12. Dispute resolution. Point A. Any and all dispute, controversy, and conflicts between the parties in connection with the service contract so far it's possible to be settled amicably between the parties. The part B is failing such amicable settlement or dispute, question or controversies arising from on connection with the contract agreement, which the party cannot settle by amicable negotiation, shall be resolved by litigation institute in the District Court of Medan, Indonesia. The next is 30, further provision. The point A is main client is not a partner or agent of the supplier and does not have a power of authority, directly or indirectly, or through its servants or agents, to bind the supplier to any agreement with any party of otherwise to contract, negotiate, or enter into a binding relationship for or behalf of supplier. Part B, its part shall be bear its own costs by expenses incurred in connection with negotiation and or preparation in connection with the contract agreement. The part C is contract agreement embodies all the terms and conditions agreed upon between the parties as the subject matter the contract agreement and suspends and cancel its respect all previous agreement and undertakings. The part D, no variation is signed by both parties and the such variation modification, waiver or consent shall be effective only the extent for which may be or given. The part E, neither party hereof shall be limited to order for default its obligations under contract agreement when such default is reason 1. Act of God, extraordinary, unforeseeable manifestation or forces of nature beyond the powers human invention, such as tornadoes, hurricanes, typhoons, and earthquakes. The third is war or armed conflict or ex-terrorism, which include the description of civil authority, transportation and communication service entering material in law, or military involvement. The third is other act of natural disaster. with like the pandemic or describe civil national as a well business and commercial activities beyond reasonable human control and beyond the occupancy party controlling, including but not limited to partial or complete plant shutdown.
Continue, the last one is number 14, is governing language. In complicates with the Law of Library Indonesia number 24 of 2009 regarding national flag language, coat of arms and attempt with contract agreement shall be prepared in both Bahasa Indonesia and English language. In the event of any incoherence between the Bahasa Indonesia, the meaning is interpretation of certain provides the parties hereby agree that the English text shall prevail.
Yeah. Okay, so we are finished to review our contract agreement of heavy equipment. So PT Maju Steel Maneuver, do you have any comments?
In my, I have any comment. It's totally clearly.
Okay, so
Is
any other comments? Okay, I take it as no comments, and I think the contract agreement quite clear because we have been past this for a years. So we will send the hard copy of the agreement by today. I hope PT Maju Steel Maneuver also sign the agreement with Matrai. We will send the hard copy of agreement and will inform you back on the email.
Okay, Miss Sherly. I will sign and send it to your company.
Okay, not Miss Octaviany. Thank you very much. I think if there is no comment, we will close this meeting. So thank you guys for joining the meeting. I hope we can make a business relationship for a long time between both companies.
Thank you.
Yes, Mrs.
Thank
Sherly.
you.
Can wait you to arrive in Hawaii. We will talk it about a working relationship to make it clearly and more relaxed.
Okay, thank you all. Nice to meet you.
Nice to meet you too.
Nice to meet you too.